Let's go. But the Baker she gonna be sitting in the second seat. Yeah. Miss Baker, you want you to come up to that first row seats? Right there now, walk all the way, no, yeah, walk up behind the wall. Walk all the way to the end, you're gonna sit in that chair next to that white sheet. Okay. Right there. Mr. Newman, you're gonna sit next to Miss Baker. And Miss Coleman, you're gonna sit next to Mr. Newman. Miss Cheryl, you're gonna sit next to Miss Coleman. Miss Perry, you're gonna follow Miss Cheryl and sit next to Miss Cheryl. Mr. Moser, you're gonna sit next to Miss Perry. Mr. Wage, you're gonna sit in that first chair, second set of seats, right there. Mr. Bank, you're gonna sit next to Mr. Wages. And Miss Bird, you're gonna sit next to Mr. Bank. Mr. Is Gary Jones? Okay, you're gonna sit next to Miss Bird. Miss Harvey, you're gonna sit next to Mr. Jones on the first row. Mr. Alex, you're gonna sit next to Miss Harvey on the first row, right there. Ms. Guerrero, you're gonna sit next to Mr. Alex. Mr. Terrell,
Yes,
you're gonna take that second set of chairs right there, walk all the way to the end, you're gonna sit in that first chair, all the way on that over there, to the left. Miss Bellin, just follow Mr. Terrell, and Mr. Lewis, follow Miss Bellin, you're gonna sit next to each other. And Cope?
Yeah.
There's a seat in between you and Mr. Lewis.
Yeah.
Right there. And Tran. Miss Tran, you're gonna sit next to Miss Cope. All the way, you guys, yeah, move it to the next chair. Good. Okay. Okay. Jefferson County Court at Law number 2 is now in session. I'm Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law number 2. First of all, I'd like to welcome you to County Court at Law number 2, Jefferson County, Texas. This court is a criminal court, and in this court, we handle misdemeanor criminal cases. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about is I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to maximum 10 years in the state penitentiary, and a fine that does not exceed $10,000. And if a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to maximum 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 to 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. Now, I think I missed the second-degree felony. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, in this court, we do not handle felony cases. As I mentioned to you earlier, we handle misdemeanor cases. And misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, Class C misdemeanors are cases that normally start in the city court or the JP court, which is the justice court. They come to this court when a person is found guilty in JP court or city court, and they appeal the case and they get a whole new trial. And it comes to this court, and the range of punishment for a Class C misdemeanor, if a person is convicted, is a fine that does not exceed $500. So you cannot be given jail time. However, if a person failed to pay the fine, or the fine was converted to community service and they failed to perform the community service, then the court can issue what is called a capias pro fine, which is a warrant for their arrest to either pay the fine or sit the fine out in jail. Now, the next highest misdemeanor is a Class B misdemeanor. And the range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days, or they can be given a fine that does not exceed $2,000, or they can be given both such fine and confinement. Now, a person, maybe if they're convicted of a Class A misdemeanor, that's the highest misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, a person may be eligible for probation. There are 2 types of probation. One type of probation is called deferred adjudicated probation. The other type of probation is called adjudicated probation. So you have unadjudicated probation, which is the deferred probation, and you have adjudicated probation, which is the regular probation. Okay, now you have been asked to come to court this afternoon to serve as a juror in a misdemeanor criminal case. You will be examined for inclusion on this criminal trial and in this criminal case. Our courtroom hours normally vary. Normally, courtroom hours is normally from 9 to 5. But in this court, we usually have other matters in the morning. We call them dockets. It's just a list of cases. We have a trial docket, a pretrial conference docket, and a what we call an announcement docket. We handle those cases in the morning starting at 9 a.m. And sometimes it goes beyond, it goes from 9 to 12 or 9 to 1, 9 to 2, depending on how many cases we have on the docket. Now, because we have those dockets in the morning, our courtroom hours for trials are normally at 1:30 in the afternoon. And so when the case gets started, like today, we start at 1:30 in the afternoon. Now, whether or not you're selected as a juror in this case, you are performing a significant service which only free people can perform. If you're selected, the case will be tried consistent with justice, which require a careful and correct trial. If selected on the jury, unless otherwise instructed, you will be permitted to separate at recess, for meals, and at night. Now, at this time, I must perform the first of two administrative duties. So at this time, I need each and every one of you to raise your right hand. And once I finish administering the oath, please say, I do. Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court under its direction, touching your service and qualifications as a juror, so help you God? Please say, I do. I do. Okay, you may put your hand down. The law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated on the jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now, the way I'm going to ask the questions, I will ask a series of questions. I do not want you to answer those questions out aloud. Just simply answer each question to yourself. And then once I finish asking the last question, I will then ask, is anyone disqualified under the law? And if you think that you may be disqualified under the law, then I would simply ask you to raise your right hand. And then what we'll do, we'll ask that you will come up before the bench so that we can discuss the matter more privately. And what I mean by privately, the other jurors will not be able to hear. We have our court reporter who's sitting to my left. She'll be taking down everything that is being said. So again, I'm going to ask a series of questions. Do not answer those questions out aloud. Just simply answer the questions to yourself. And then once I finish asking the last question, I will then ask, is anyone disqualified under the law? If you think that you may be disqualified under the law, I would ask that you raise your right hand. Excuse me. I would ask that you raise your right hand, and then we'll ask you to come up so we can discuss the matter more privately. Okay, now the first question. Except for failure to register, are you a qualified voter in Jefferson County and the state of Texas under the Constitution and laws of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I always pause when I get to this question because I need you to understand that I'm not trying to pry into your personal affairs. I'm only obligated by law to ask this question. And the question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? And this is the last question. Have you served as a petty juror for 6 days in the preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? Is anyone disqualified under the law? If you think that you may be disqualified under the law, please raise your right hand. Okay. Let the record reflect that no one on the panel raised their right hand. So at this time, thus far, everyone on the panel is qualified. Now I will determine if anyone who is otherwise qualified to serve as a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just remain seated. And I will ask these questions in the same manner that I asked the last question. That is, I will ask a series of questions. Please answer the questions to yourself. And then at the end, I will ask if there's anyone who would like to claim an exemption. Okay. Listen. Okay, first question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12? And jury service would necessitate leaving the child or children without adequate supervision. Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer, employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in this county during the last 3 years prior to today? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? And this is the last question. Are you a member of the United States military forces serving on active duty and deployed away from your home station and out of Jefferson County? Is there anyone on the panel who would like to claim an exemption? Let the record reflect that no one on the panel is claiming an exemption. Now I will move to excuses, and with excuses, I will not read or ask you any questions. I will simply make 3 statements. Now, if you feel that the first statement is a juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. Second statement, a juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the defense and without the consent of the state. Last statement, a juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim an excuse? Let the record reflect that no one on the panel is claiming an excuse, no one is claiming an exemption, and all the members of the panel is qualified or qualified. Okay. Let the record also reflect that the time now is 2:13 p.m. on today's date, November 3rd, 2025. And let the record also reflect that we're in session in cause number 24 CCCR 1754, case is style, state of Texas versus Jason Wayne Bickford. Let the record reflect that Mr. Bickford is present in court with his attorney Marcus Wilkerson.
Yeah, man.
Let the record also reflects that the state is present with Assistant Criminal District Attorneys, sitting first chair, Attorney Haley Simmons, and sitting second chair, Attorney Shane Hilton. And we have in the jury box, Mr. Andrew Hubert.
Yes.
The bailiff in this case is Ms. Brenda Mosby. I think you met Ms. Mosby earlier. Our court reporter is Ms. Ada Christie. She's sitting to my left. Now, when you are speaking or answering any questions, please speak up so that Ms. Christie can hear you, because she's taking a record of everything that is being said. The defendant in this case, Mr. Jason Wayne Bickford, is charged by information with the Class A misdemeanor offense of assault causing bodily injury to a family member. This is a Class A misdemeanor, and I did mention to you the punishment range for a Class A misdemeanor, which is minimum 0 days to a maximum 365 days. Fine that does not exceed $4,000. A person could be given both such fine and confinement. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we may discuss the matter more privately. State, are you ready?
Thanks, Your Honor.
Defense, are you ready?
We are, Judge. May we approach briefly?
Okay.
Just put something on the record real quick.
Oh, yeah, hold on. Ms. Simmons, the panel is yours. How much time do you need?
Half an hour, I believe, Judge, but
Okay, if you need more time, just let us know. Okay, and I will be keeping time.
thank you, Judge.
You're
Good
welcome.
afternoon. I'm a little happy to be here. All right, just show of hands, this hurts my feelings every single time. I promise I try not to take offense to it. Who was excited to be here today? Okay, I have that. You're happy to be out of school today?
Oh.
I understand. A couple weeks ago, absolutely no one raised their hands, so I appreciate the compliment did. So what we're here today is for an assault. I'm just gonna read out the offense for you. We're gonna break it down a little bit as we talk. So a person commits an offense if the person intentionally, knowingly, or recklessly causes bodily injury. And here we're talking about to a family member, household member, or dating partner. So I just want to start off right off the bat. Has anyone here in this room ever been a victim of assault? So breaking down, I obviously have a burden. I have to prove it just like it as a juror in this case. What I have to prove to you is that defendant, on or about a certain date, in Jefferson County, Texas, did intentionally, knowingly, or recklessly cause bodily injury to a family member. Each and every single one of these points, I have to prove beyond a reasonable doubt. So this is the checklist. We're going to talk about it today. And if you're selected as a juror, I want you to keep this in your back pocket, okay? So what does bodily injury mean? Someone gets to cheat. I have the answer up there. Who wants to tell me what it means? We have to talk, guys. I'm gonna start picking on people. Anybody?
Cocaine, illness, or any impairment of.
Physical condition. I'll help you out there. Thank you. I would throw out a Jolly Rancher or some candy to give you for being an old star. Does this mean that seriously bodily injury must occur? There must be serious injury. Anybody? Yes or no?
No.
Everybody agrees no? Does anybody think that you actually have to have some form of serious injury? Good. We're starting off good. Are the injuries required to be visible? I'm gonna pick on a specific juror here. I might just make my way down the row. Juror number 2, is it Ms. Baker?
Yes.
Do you think injuries are required to be visible for an assault to occur? No? Who here thinks that there needs to be an injury? Seen, visible. I promise y'all can tell the truth, okay? That's what we're here for. Board dire and fancy words, it just means to tell the truth. We're just trying to find the best fit here. Everybody agrees that no actual injury needs to be seen. All right, as long as y'all start talking. Last one, must the victim feel some pain? Mr. Newman. Yeah. I'm talking to you. Well, I know you're not.
I'm hard of hearing, I'm sorry.
All right, must the
What's
victim,
the,
oh, that's funny, okay. Must the victim feel some pain?
I would think so.
Okay, everybody agree with that? And I've got that handy dandy definition there, means physical pain, illness, or any impairment of physical condition. So to meet my burden, when I say bodily injury, I'm really saying pain must be felt, right? Can we all agree with that?
Right.
Everybody start getting scared because you know I'm going down the way, okay? All right, family member. Can you give me an example of a family member, juror number 4, Ms. Holman?
A brother or a sister.
Okay, so we're talking blood. And you're gonna see a fancy word up here, and we'll hold this maybe so angry, consanguinity or affinity. Those are just fancy words for blood or by marriage. So does it have to be by blood? Do you remember 5, Ms. Cheryl?
No, it doesn't have to be about love.
Okay, what would an example of someone not by blood be?
A friend or,
In the family member, right?
yeah.
Someone by marriage possibly. And we break that down right here. Anyone related within 3rd degree of consanguinity, that big fancy word, or affinity, including former spouses. Household members, just talk about the units of the family. Dating relationship, people that are obviously involved romantically. Any questions on what a family member is here? Pretty straightforward. So, I'm gonna keep going down the way. I have Miss, is it Parrot?
Yes.
Did I say it right? Okay. What do you want to see in this type of trial? To determine whether a defendant is guilty?
Information from both sides. Pros, cons.
When you say pros or cons and information, are you talking about you want to hear from somebody on the stand?
No, I'm still, this is the general, information about what happened, just.
You want to hear witness testimony, evidence, right?
Yeah.
And we all know that when somebody's on the stand, my questions are, or Mr. Wilkerson's questions, that's not evidence, but the answers from a witness is absolutely evidence. So you're correct there. What do you want to see, juror number, is it Mr. Moser, 7th?
I guess it's beyond reasonable doubt.
Yeah, but what about evidence wise?
Evidence wise, I don't know, I don't really have a thought on the matter, just be convinced by whatever is on the evidence, he's presented that.
You wanna hold me to my verdict? Perfect, as you should. Juror number 9, Mr. Wages, is there anything you wanna see?
Pretty much second these things. I mean, I want a fair and just trial. I mean, I want to listen to what they have to say.
Let's break it down though, evidence, we wanna see pictures, right?
Right.
Possible body cam.
Yeah.
Anything that I can show you that would make me meet my burden. So obviously, we're talking about, okay, CSI guys, scrap it, I tell every single juror this. This is actual court, I know CSI and all those things can be fun to watch, way different ballgame. So of course, we're talking body camera footage, possible photographs of any injuries. Witness testimony, which again is evidence, like you stated. This is an everybody question, and I'm gonna read it out loud so everybody can get their numbers, okay? If supported by the evidence, how comfortable would you feel finding someone guilty of assault without visible injuries on the victim? So I'm gonna read it out, and while I'm doing that, I want y'all to get your numbers down, okay? I'm gonna go down the row. 1, very uncomfortable. 2, uncomfortable. 3, somewhat uncomfortable. 4, somewhat comfortable. 5, comfortable. 6, very comfortable. Has everybody got a number in their back pocket? I'm gonna start with you, Miss Baker, just to make it really easy. Can you give me your number? You want me to read that question? 4?
6.
Your number 4?
4.
5? 6?
6.
7?
4,
8?
6,
9? 10? 11?
4,
12? 13? 14? Can't count. 15?
3,
16? 17? And then we're missing 18, 19? 20? 4. Alright. Good. So, I am, who am I on? Did I ask you a question yet? I think I did. Alright, Mr. Mayor, what do you expect a victim of an assault to look like?
Potential bruising, like visible. Is a visible bruising potentially, of assault.
Okay, so you're saying visible bruising, but do you think that that's required? Do you have to
No,
see
not
that?
required, but,
Okay.
I mean, but also somebody who, I guess, is dealing with, potentially trauma out of that.
Okay. How should they behave?
I mean, I would say, the majority of the time, like, kind of very timid, kind of reserved.
Okay. Juror number, let's say 10, Ms. Bird? Are all victims meek, timid, and shy?
No, I don't think anybody, would. There's not one way somebody could behave because you don't know everything that.
Just out of curiosity, just really want to get your opinion. Do you think it would be odd if maybe a victim was laughing or hysterical after the fact? Anybody think that would be odd? No? Anybody think that might be normal? I hear juror number, is it 19? We're here to speak the truth, so it's absolutely okay.
You know, I don't know, everyone feels different,
Right.
you know, when something traumatic happens to them, so we deal with it differently.
And that's kind of what I'm getting at. Can everybody here understand that a victim or a complaining witness might actually act different than how you would react if you were assaulted? Does anybody think that there's actually one set way they have to respond to being assaulted?
it becomes a norm sometimes.
It becomes a what?
Becomes a norm,
So they just kind of maybe expect it.
right? It's, they've lived through it, and this happens over and over and over.
Good. One witness. Let's talk about the one witness rule real quick. Texas law does not require a particular number of witnesses to a crime. It just requires me to prove my case beyond a reasonable doubt. Why do you think that is, Mr. Jones?
Because it only takes one person to have something done to them.
Okay. Only takes one person. Does anybody think I have to have absolutely more than one person? If a witness came in here and testified as to every single element and I met my burden beyond a reasonable doubt, do you think that should satisfy my case, my burden? So let's kind of break it down. I'm gonna go to, I don't know, I'm picking on you, I'm coming down the road. Ms. Harvey, who decides where a crime occurs? Okay, did everybody hear that? Just real quiet, you just speak up, I got my court reporter, she wants to hear you. What did you say?
Trick questions, but they're not.
Now, who's talking?
The person who commits the crime.
Okay.
Decided where it occurred.
Show of hands, who here agrees that? Did you hear it? The person who commits the crime is who decides where it occurs. Who here would agree with that statement? Loud and proud, guys, raise your hands for it.
Yes.
Okay, who here thinks that would be the case? Okay, who decides when the crime occurs? I'm gonna go to you, Mr. Alex. Same person? Okay. Who decides how many people the crime must occur in front of? You already know, is it Guerrero?
Yes.
Who decides how many must occur in front of?
The same, the person committing the crime.
Y'all get where I'm going with this?
Yes.
We're talking about the one witness rule. Therefore, if one witness can testify to each and every element of the offense, and you believe this beyond a reasonable doubt, the law requires that you find a defendant guilty. Is there anybody here that would have a problem with this one witness rule? You say no? You said no? Okay. Sorry, I've got to keep up with your talking. Everybody agrees with this? Things I'm not required to prove, but I will say these are things that you can consider. I'm not required to prove motive. I'm not required to prove how many times they were struck, the size of the victim, the size of the defendant who was present for the assault. I just have to meet my burden. But of course, these are all factors that you can consider if you're deliberating, if you're selected as a juror. Reasonable doubt. So Texas law requires the state prove its case beyond a reasonable doubt. Does anybody here think I can give you a definition of that term? Juror number 15, Mr. Terrell, do you think I can give you a definition?
I think you can. You can try.
I can try. Well. Is it Ms. Valon?
Yeah.
Did I say it right?
Yeah.
Okay, do you think I can give you a definition?
Yeah.
Okay. This is really small, I'm gonna read a second. Texas law does not allow me to give you a definition of this term. I can't do it. We're gonna talk a little bit about that, but it's not beyond all doubt. If you were there, and of course, y'all got all the answers to the test up here. If it was beyond all doubt, where would you be in this courtroom? Anybody? What'd you say? At home. Well, you're here with me, hanging out today. But if it was beyond all doubt, this is where our witnesses come testify. You'd be sitting right here telling me what you saw. Because if it was beyond all doubt, that means you probably saw it, right? Not at home. I know you want to go home. I know you didn't raise your hand saying you're happy to be here. It's not beyond a shadow of a doubt. It's not beyond an unreasonable doubt. The best way to explain it, and I'm sorry, I know you wanted that definition, you're gonna know it when you see it. Does everybody understand that at their best? So really, it's just common sense. I don't think any of us checked it at the door when you're getting your metal detector and trying to get in here. Now you're also eager to get here for. These are puzzle pieces, by the way. Okay, I know it's hard to see. Mr. Lewis, what is that puzzle gonna make a picture of?
I have no idea.
You only want to take a guess?
Probably need a couple more.
You need a couple more pieces. Can you tell me what it makes now?
It's like I don't know.
Firearm. Is it still missing some pieces?
Yeah. Yes.
Can everybody see a firearm in this picture? Or pistol? Okay. Same as trial. Evidence provides the pieces to the puzzle. You might not have every single piece. Again, we can't all testify up here as to what we saw because we weren't there. However, we see a gun, we see missing pieces. You're going to be able to infer from all the evidence and put that together. And if you're selected as a juror and you go back and deliberate, if you believe beyond a reasonable doubt I have met all of my burden, you must find the defendant guilty. And if not, you would acquit. Everybody can understand the breakdown of the puzzle piece? Presumption of innocence. Everybody has it. If you were to vote right now, is the defendant guilty or not guilty?
You don't know. I don't know. I want to see X-rays and pictures.
You wanna see x-rays? Anybody else wanna see x-rays? Now, if I tell you, we talked about it, not all injuries are visible, would you still wanna see some x-rays?
It would help.
Okay. Everybody agree?
Almost.
The more the better, right?
Somebody.
Hold me to my burden, absolutely.
Injuries though, can be mental or physical.
Through that.
Well, remember my burden. Now, we can't break down injuries in terms of mental and physical, but whenever we talked about it, physical pain is a requirement. So we gotta make sure we meet my burden correctly there. So physical pain is required, but of course, the visible injuries is not something I have to show. Does that make sense? I know. She's rolling her eyes at me, guys. Means the state has to prove the defendant guilty beyond a reasonable doubt. So the defendant, his verdict is what? Nothing. Sitting right here, does he even have to put on a case? Where are they not picked? Jury number 20, did I get to you, Mr. Ed? Okay, all right, your turn. Does he have to put on a case? Yeah. No. The burden rests entirely with the state. He doesn't have to prove himself guilty. He doesn't have to prove himself not guilty. It is my burden to meet. I have to meet every element beyond a reasonable doubt. So you hold that burden on me, okay? Subpoena power, the right to discovery, the evidence you want to see so bad, Miss, is it Miss Parent?
It's mad.
Right to trial, which is why we're here today. Right not to testify, and let's talk about that one. Would anybody hold it against the defendant if he chose not to testify? Juror number 19,
Maybe,
maybe.
I can choose.
What's that?
Why does he choose not?
Now he has the right not to testify. But is that something you would hold against him if he didn't?
I don't know. I mean, I think like you say, the puzzle pieces, there's so many. And as you start to bring those puzzle pieces in, it helps answer a lot of questions that will be brought up, I assume.
Okay, now everybody here understands though, the defendant has the right to actually not testify. And by law, you're not to hold that against him. Speak up,
By the Fifth Amendment, but you don't have.
there we go. Right to defenses, of course. All right. We're gonna talk about this. I won't take up too much of everybody's time, but when we're talking about victims of family dating, raise your hand if you know anybody that has been a victim. Not if you've been a victim, but if you know anybody. Okay, I'm going to circle, raise it for me. 3, no, 4, I'm missing one. Actually, I've got 6. Will you say your numbers for me as I get to you?
10.
10, 11,
14.
15.
17.
okay. Would that, I'm gonna ask each and every single one of you, would that cause you to be not fair, or would it cause you to not be impartial in this case? Juror number 6, would you be fair and impartial? You'd be able to set this aside? Okay. Juror number 10, would you be able to be fair and impartial? Juror number 11? Juror number 14?
Yes.
Juror number 15?
Yes.
Juror number 16? And juror number 17? Okay, does anybody think assault or family violence is a problem in our community? Show of hands again. Every day? Every day? Okay. What do we do about it?
Oh, you don't want.
No, I wanna hear it, we're gonna talk. Okay, there you go. There you go. But what do we do about it? It's a serious problem, right? We all agree to that. We hold people accountable, right? What happens when we hold people accountable? Anybody? You look so good.
I know you have.
Read your face.
So, well, you just want things to be looked at and investigated, or, you know.
We wanna stop it from happening,
There's
right?
two sides to everything, and just everybody can just hear it out and see what the issues and problems are.
Correct. So when we hold people accountable, we're deterring future action, right? Does everybody agree with that? It's a serious matter to take to trial. So I'm gonna ask these questions, and again, I'll try to be quick. Victims of family dating violence again. Those that know somebody, did the person leave right away?
No.
Okay, did they report it right away? No?
Yes.
Yes.
Yes? Now I got no's and yeses. I'm gonna pick on 14 and 15 real quick. No, they did not report it right away. Do you think that's normal?
I think, you know, depends on the person, some people who don't report it right away might be scared to report it right away. I don't think either or is normal, I think it just depends on the situation.
Juror number 15, you said yes.
Yes.
It's kind of the same answer.
Yeah, it just really depends on the person.
Right. That's kind of what we talked about earlier when we were talking about are all victims shy, meek, timid, or some possibly hysterical. Everybody responds differently. And just give me an example, juror number, okay, what's number 9. Why would someone not report it right away? Why do you think?
They may have just thought it was like a one-time occurrence, or they just, like, maybe they just have gotten mad and it wasn't something that was gonna be on the regular. Or, that it was a misunderstanding.
Everybody understand? Everybody agree with that?
Yes.
Might there be other reasons?
Just afraid of the person that saw it.
Fear? Okay. Let me ask you this, juror number 14, did they go back?
They did go back.
Juror number 15, did they go back?
Yes.
How many times did it happen before it stopped?
A lot.
A lot. Juror number 15?
Yeah.
A lot. Everybody see what I'm getting at here?
Yes.
Did they call the police when it happened?
On some instances, they called the police, but they still went back after the fact.
Number 15?
Yes.
I'm going back and forth, y'all, because y'all got the opposite answers there. So we already talked about some reasons, fear, possible intimidation. Everybody gets that. Everybody's gonna respond differently. And with that, if you're selected as a juror, I ask that you hold me to my burden and listen to the witness testimony before making that determination, okay? So a jury's duty, don't know how this got offset, but decide the facts, apply the facts of the law, and follow the law. And the law, you're gonna get a jury charge whenever you're going back to deliberate from the judge, and that is the law you're required to follow in this case. That's it for me. I know y'all are tired of hearing me talk. Does anybody have any questions for me? This is the last time I get to talk. Well, if you're selected as a juror in this case, I really look forward to presenting the case to you, and thank you so much for your time.
Mr. Wilkerson, panel is yours.
Oh, my. Want this? It's gonna tell you no, but.
Don't know.
Just that you weren't gonna
I
cross me.
swear,
Not-
if I don't catch something, I'm gonna tell you to.
Don't worry about it.
Give me just a minute here.
Just, you can leave it on the ground, Marcus will take care of it.
Huh?
Just leave it on the ground, we'll take care of it.
Oh. I gotta make sure it's not near real quick. Don't.
IT's coming in.
Andrew. We worked last week. So. Equipment.
You wanna email it to me, Marcus, and just put it in mine?
Yes, let me do that. Thank you. You're different than your code.
Can I take a little bit?
If they want to take this
If
short.
they wanna take a short break, Judge, so we can get this set up, if you wanna ask the jury.
Okay. Okay, ladies and gentlemen, of the panel, we're gonna take a short recess. I'm gonna ask that you please stand. Follow the bailiff into the hallway. You can go out either one of the doors. Okay.
Just sit anywhere.
No. Okay, you may be seated. Okay. Let the record reflect that the court is back in session and calls number 24 CCCR 1754. Case is filed in the state of Texas versus Jason Wayne Bickford. Let the record reflect that Mr. Bickford is present in court with his attorney. Attorney Marcus Wilkerson, the state is present also with assistant criminal district attorneys. Attorney Haley Simmons, Attorney Shane Hilton, and Attorney Andrew Hubel. Mr. Wilkerson, the panel is yours. I'll be taking time.
Thank you, Terrence. Good afternoon. As you've heard a couple of times, my name is Marcus Wilkerson and I represent the defendant in this case, Jason Bickford. I want to dive right in and start with something that y'all were asked during the state's presentation. And y'all were asked if you had to make a finding right now, what would it be? And the one thing that I guess scared me about that, and maybe answers have changed after some further explanation, is that nobody said not guilty. Can anybody explain why it would be not guilty?
Evidence is not proven here.
Right, so it goes at number 10. Correct. So the presumption of innocence, right, what that means is that unless the state proves its case, the verdict will always be not guilty. Unless they prove their case beyond a reasonable doubt. So, voir dire is just a fancy word, meaning to speak the truth. And so talking about some concepts, now this is for an indictment, but in misdemeanor court, well, does anybody know, can anybody explain the difference between an indictment and an information? I wouldn't expect you to unless you worked in a clerk's office or something like that, or were an attorney or knew somebody who were close to somebody who practiced criminal defense law. An indictment is when a case goes to a grand jury and that grand jury votes on whether or not probable cause exists to proceed against that defendant. Now, in a misdemeanor case, because even at the highest level of misdemeanor, the maximum penalty is 1 year in the county jail. You don't have to seek an indictment from a grand jury. So what that means is that if a police officer writes a probable cause affidavit, then you can then get an information file, right? A complaint is filed and then information is filed by the state's attorney. Who in here believes that the information is proof of guilt? Anyone? Anyone believe that by sitting in that chair right there, that means that the defendant actually committed this offense? So when you're talking about presumption of innocence, there are some kind of fun little things I like to do in talking to jurors. How many of y'all are married? The majority of you, right? So for the ladies out there, if your husband came home and that was on their shirt collar, how many people are gonna immediately flip out? Okay, hey, y'all are being honest, I appreciate that, right? So, but what the presumption of innocence means, right, is that if you were to come home and see that, your husband comes home and sees that, you first inquire rather than immediately flipping out, right? When we're talking about criminal law, because the penalties are so severe, right? And because the state has the full authority of the state of Texas, you know, versus one little person, that's what the presumption of innocence is about. Somebody complete this statement for me. Innocent, blank, proven guilty. All of y'all said until. In fact, so let me just, again, language is a powerful thing. Anybody disagree with that? Yes, ma'am. Juror number 4,
Innocent unless proven guilty.
unless. Can you explain why it's unless and not until?
Because like she was saying, she was a burden on her to show us basically her facts, and we either have to like, you know, unless she shows us all those reasons that he's guilty, he'd be innocent otherwise.
Thank you. Thank you very much. So, if you say until something happens, that presupposes an, right? If you're saying that until this defendant is proven guilty, then in your mind, you're already thinking, okay, he's guilty and I've just got to wait for the state to prove up that case and then I can go along with that. That's why it's unless proven guilty rather than until proven guilty. Right? How you frame things in your mind has a very potent, even if subconscious, effect on how you view the world. Language has power, right? And so the words that we use have power. Who here can tell me what that says? How many people believe it's jumping to conclusions? Raise your hand. More said it than would you raise your hand, right?
I mean,
It's not a
progress,
trick.
that doesn't mean that's it.
So, as you can see, right, jumping to conclusions when you only have half the story, yeah. But as soon as it's uncovered to reveal the whole incident or the whole statement in this case, jumping to conclusions falls away. What is that, ma'am?
Missing pieces.
Missing pieces, okay. That's one answer. What is that a photograph of? Or picture of? Weapon? Alright, so that looks like it's probably a 45 caliber. Everybody agree with that?
Close enough.
Okay, alright. What is it now?
Oh, again.
Toy. So it's important to have the pieces. Yeah, you don't have to have every piece, but you never know where that fundamental piece may lie, right? And so when the state's attorney, for those of you who end up on this jury, right, when you are listening to the evidence, be sure that you are thinking outside the box, right? And questioning why certain behaviors took place. You have to be willing to look at the whole picture, right? We talk in law about a lot about the totality of the circumstances. Does the totality of the circumstances prove something? And the reason that we talk about totality of the circumstances is because you can, if you jump to a conclusion without the proper evidence, then you can make a mistake, right? How many people, well, can we all agree that over the past 20 years, there have been a number of exonerations of criminal defendants. Anybody disagree with that statement? Maybe it'd be easier to go that. Nobody disagrees, but everybody's just kind of scared. I'd rather be at home. All right. So for those cases where defendants have been exonerated, does anybody believe that all of that was a malicious jury who were seeking to put away someone who was innocent? Anybody believe that? Even if there were quote unquote malicious actors on any given jury, you're not going to get 12 of them, right? You're not going to get 12 people who are so biased that they're going to immediately convict somebody without evidence, right? So those jurors, those juries, when they hand down that guilty verdict, they've done the best job that they could under those circumstances, right? But the point is, there are times that a jury gets it wrong. So with that in mind, I want to ask y'all, so there's a maxim that we sometimes discuss in, at least in the field of law, when we're talking about criminal matters. So what I'm going to do is, much like you had a somewhat comfortable or not comfortable selection during the state's presentation, I'm going to give you a statement and then ask you to go, ask you for your response on a number scale, right? Number 1 will be strongly agree. Number 2, agree. Number 3, disagree. Number 4, strongly disagree. The statement is, I would rather set free a guilty person than convict an innocent person. Juror number 2?
1.
You're juror number 3, right? Yeah, so, okay.
Make that
Yeah.
question, that's why.
Right, there's some, I'm gonna go all the way down the road, so I'll go over it again, right? So with, 1 being strongly agree, 2 being agree, 3 being disagree, 4 being strongly disagree, the statement is, I would rather set a guilty person free than convict an innocent person.
Yeah. 1.
1, okay. Juror number 2 is a 1, thank you. Number 3. Number 4. Number 5.
1.
Number 6.
1.
Number 7.
2.
Number 8.
2.
Number 9.
2.
Number 10.
Will you repeat the Lambert scale one more time?
Yes, ma'am. So 1 is strongly agree, 2 is agree, 3 is disagree, 4 is strongly disagree, right? So, and the statement is, I would rather set a guilty person free than convict an innocent person. Do you agree or disagree with that statement?
2.
Okay.
11.
Well, thank you. Well, 13, 14, 15,
3.
16,
2.
17, 18, 19,
Two.
20.
2.
2. All right. Thank y'all, and I appreciate your honesty. Everybody thinks we're asking like trick questions, trying to trip y'all up. I promise we're not. It's not, I'm not trying to trip you up or confuse you. We only have a few minutes to stand up here and get to talk to y'all. And in that few minutes, we have to try and get to know you and try and figure out a little bit about how you think about issues, right? And so in determining whether or not somebody might be appropriate or inappropriate for a particular jury. Alright, so anybody want to describe what they see in this photograph? Nobody willing? Come on, somebody has to be brave.
A woman, black shawl, she's got a feather. Hair.
Okay.
hair, breath.
Poo-poo
That's what I
hair
see.
and feather and,
Anybody see anything different?
yeah.
Recent.
An older woman that's. Yeah, an older woman, her face is the watch mark.
Somewhat haggard, maybe.
Yeah, there you go.
So, right, if you're looking at it that way, and both of the yellow marks are the eyes, and the bottom yellow mark is the mouth, then you're going to see an older haggard lady. If you're looking at it where that yellow dot is an eye, right? And then what was the other eye as an ear, the picture changes dramatically. So it is possible, right, for two people to look at the same picture, right? Let the picture be analogous to situation, but it's possible, right, for two people to look at the same picture and see two different things. Anybody disagree with that? Everybody understand where I'm coming from? See head nods, that's good, that's some interaction. All right, already did that one. So when we talk about the burden of proof, and beyond a reasonable doubt. Sorry, y'all, I've got dry mouth issues, COPD, bone issues, it's no fun. Anyway, so when we're talking about the burden of proof, right, beyond a reasonable doubt, we are no longer allowed to try and give you a definition or try and pigeonhole the phrase beyond a reasonable doubt. And so what we try and do is get potential jurors to think about in their own mind what type of evidentiary proof they might want to see. And so the way I do that, I like to ask, for those of you who are parents, and I think there are only like 3 or 4 of you here that have never had kids, or at least at present don't have kids. Anybody want to take a guess at what the standard or burden of proof is in order for the state to terminate your parental rights? So if you were a parent with a child, what burden do you think the state should have to carry if they want to terminate your rights to your child? Anybody? Your number 2.
Evidence of abuse, whether it be a family member or just.
Okay.
Witnessed or heard or.
So you're looking for evidence of abuse. The question, what I'm trying to get y'all to consider is these steps, right? Because I talked to y'all about probable cause, which doesn't mean that somebody probably did something. That's not what probable cause means. It means that there's probable cause to proceed in an investigation. There's probable cause to proceed in filing charges against somebody. There's probable cause to make an arrest, right? Probable cause is the same standard that's required to execute a search warrant or an arrest warrant. We have a right against unlawful searches and seizures, right? And so when we talk about unlawful searches and seizures, what we're talking about is searches and seizures, whether it be of your person or of some other evidence that probable cause burden is met. And so next, right, you got what's called the preponderance of the evidence standard. And I know there are a few of y'all here. Juror number 8, Mr. Wages, you've been on a civil jury, correct?
Yeah.
How long ago was that?
10 years ago.
Okay, so it's been a little while. You wanna take a shot at, what probable cause means? I'm sorry, what preponderance of the evidence means?
They had to prove. They showed us that. I don't know. I can't remember what's-
It's okay, I mean, it was 10 years ago.
Yeah, I
And
mean, it's been a while.
you know, unless you are in criminal justice or in the legal field, this is not necessarily something I would expect you to know. So the civil standard is preponderance of the evidence, right? The next standard up on our ladder there. And that just means that it's 50.0001% more likely to have occurred than not. Right? That's the standard of proof if you're across the hallway and there's been a car wreck or somebody's breached a contract or something of that nature, right? The next step then, that's higher than that, but lower than beyond a reasonable doubt, is clear and convincing evidence. And ladies and gentlemen, I submit to you now that clear and convincing evidence is the standard or burden of proof to terminate a parent's right to their children. So the state, in order to say you no longer have rights to your child, right? You no longer have any authority over them. You no longer have any right to access any information, know where they are, anything like that. You're done. For all legal purposes, you are no longer the parent. That standard of proof is clear and convincing. Not beyond a reasonable doubt. Have COPD too, I think I mentioned that. So if I seem like breath shaky or have to stop and breathe a couple of times, that's why. All right. So, and then there are other ways to frame this, right? But this next chart is the one that I like the most because it puts things in colloquial terms, common terms, those that we use regularly, right? And so if you're going up the right-hand side, everything from believe not guilty, guilt likely, strong belief of guilt, still doesn't get you there. That's not beyond a reasonable doubt. Now, they don't have to prove their burden beyond all doubt. That's not their burden. But is there a reasonable explanation? Is there a different reasonable explanation for the allegations made in whatever case you're judging a defendant? Anybody have problems with that position? I asked y'all about that. When I say that position, what I'm talking about is sitting in judgment of someone. Some people have religious reasons that they can't or don't, and so that's why I asked. It's an unenviable task in my personal opinion, and so those of you who are selected for the jury, you have a difficult job. And that job commands a great deal of respect from us. Without you being here, without your participation, without y'all showing up for jury duty, right, this defendant wouldn't have his day in court. So, keep that right there. Let's see, juror number 9. Your father is in law enforcement, right?
He was.
He was?
Yeah.
Anything about that that would cause you to have a bias toward the state as opposed to the defendant?
No.
Okay. Thank you. Juror number 13, you had a cousin who's in the FBI, correct?
Yes.
Same question. Anything about that relationship or anything you've talked to your cousin about over the years that might cause you to have a bias against somebody who has been charged or alleged to have committed an offense? Juror number 6, your husband actually was in law enforcement, correct? Did he, I don't want to open an old wound, but did he pass away in the line of duty?
No.
No? Okay. No. We're all grateful for his service nonetheless.
Also have son-in-law, that's police officer.
Okay. Anything about those relationships that might cause you to be biased toward the state in some way?
I have questions. I asked my son-in-law, because this is my job, what I did before I retired, and this is just very interesting, and I ask questions on law to him because I just don't know the law, or how you find out something you want to know, but you ask questions, so.
Yes, ma'am. Yes, ma'am. Anything that has been shared with you that might cause you to be biased toward the state as opposed to the defendant in this case?
I have,
And there you go. We all have opinions, you know.
that's the,
There are-
everybody out.
There are lots of little sayings about opinions, you know, that are not necessarily appropriate for me to share in this city.
Sure.
You have served on a criminal jury previously, correct? Did y'all reach a verdict? What type of case?
It was a, wreck, it was, I think it was, actually, I think it was a police car outside SWAT, or something like that.
Was it some sort of intoxication offense or leaving the scene or do you
No.
recall? How did it come out?
It could,
Guilty. I saw a few others of you had some prior experience on criminal jury. Ms. Baker, you've served on a criminal jury before, have you? No? Nope. Sorry, y'all, when we're talking to y'all, all we have to go by are these little cards y'all fill out. So, we take these cards and then as best we can, we formulate questions to try and get to know y'all a little bit more. So, I must have read something wrong. You have a relative who is a police chief, is that correct? Is that local or Chambers County? Anything about that would cause you to somehow be biased toward the state's case in any way? Anybody know Officer Billingsley? Like, okay. Anybody know, I'm sorry? Okay, you've heard, but not personal relationships with, okay. So, thank you. And then, anybody know Destiny Fawcett? Or think that?
Oh.
Yes, ma'am. Are you comfortable sharing that in this open?
I can, so, I played roller derby for, 7 years.
Mhm.
And, I know that is the sister of one of the players that, married or was, to Mr. Bickford.
Okay.
I retired there, stopped doing that in 2020. But I haven't seen the dealer for him and, since our
Okay,
child was little.
So you also think you know the defendant as well? Okay. But it's been years and years since then. Anything about those relationships that might bias you either towards the state or toward the defendant?
No, I mean, we went to practice and I spent, practice time, with them, but we kind of did what we needed to do. If you're in a sport, do we hang out after sometimes? Yes, but I wouldn't say, well, like, hey, come over to my house, kind of, thing. It'd be similar to like, if you work with somebody like at a school, hey, you're my classroom neighbor, I might, see here and there, if you brought a family member to a
Yeah.
school thing, I guess.
And again, we're talking about at least 5 years prior. Going
Oh,
back,
it's 25, yes,
yeah.
yeah, cause I started off with COVID. Yeah.
Good,
and I
yeah, you
started
said
teaching.
2020.
Yeah,
Sometimes when you hear like.
That's how I know.
Yeah, 5 years ago, when
Yeah.
you're like, no, it can't be that long
Yeah.
ago, and then you're like, wait a minute.
Yeah.
That's what
I mean,
happens
now
to me anyway.
I am still friends with Whitney on Facebook. But I'm a teacher, mom,
But I don't really get on Facebook, but she is my Facebook friend.
You're Miss Carly, correct?
Mhm.
Alright.
I don't know, she still wants when she came to practice or something, visit.
Okay.
Listen.
Thank you. Um. Let me see, you're number 12. You work at a women's resource clinic, is that correct? Can you tell us a little bit about that?
That's a pregnancy center.
Okay,
We offer free services. It's a nonprofit.
okay.
It's like a pregnancy medical clinic.
Is it religiously affiliated in some way? So you were asked, that talked a lot about, why other people may not have been around for something, when something has occurred, or, nobody else witnessed it. And that it was, the decision of the person who committed the crime or offense, right? Um, are there reasons that somebody would lie about having been assaulted?
Yes,
Yes,
yeah.
and you are Miss Guerrero, correct? What's one of those reasons?
A reason someone could lie about being assaulted is maybe that they're ashamed
Of,
of it happening and maybe not reporting anything.
do you think that it's possible for someone to lie and say they have been assaulted when they haven't? Can you give me a reason that someone might do that?
I don't have a specific reason. I mean, I know I've seen instances
Mm.
like that,
So, anybody have a relative or have a friend who has a family member that is malicious? Anybody know anybody like that? Yeah, you're number 4, had your hand up. Tell us a little bit about that.
I mean, I think that when it comes down to like family cases and civil cases and stuff, it can be sticky, like, family feuds and, if, I don't know, the scenario, but if someone finds out their spouse is cheating or something, now it's more of like a malicious thing. I don't want you around the kids. Like, there could be many factors that play.
Right, so false allegations to try and favor someone for some sort of other action, maybe a divorce or custody, something like that. Good, good. I believe, who was it over here that raised their hand? You did, I'm sorry, Miss Parrot, is that correct?
My dog,
Daughter,
and the last time it happened, I was visiting for a weekend and I heard my now ex-son-in-law, assaulting her. And one thing led to another, and we all ended up in the living room, and he left out the front door very fast. And in a few days, he probably had a few bruises. Cause, yeah,
was that an instance of where one party lied about having been assaulted? No?
this had happened prior to her, and she hadn't told her, my parents, but I was there visiting and I heard the assault. And-
So she hid it from your parents
Oh, yes.
so that she might not face judgment from them about being with someone who's abusive?
She didn't ever let my dad know, because, he would have come, it was in Orange when it happened, he was in Orange, he would have come where he was living at. And I'm not sure what would happen, but
let me ask, let me ask it this way. If somebody is taking delight in the actions that they have caused, how might they react to that? Might they be boisterous and laughing and happy and joking around about it?
If they're been taunting somebody and wanting to, be convicted. And lots of things.
What about financial motives? Anybody have any experience where someone owed one person money and didn't want to pay it, so made up some allegations? Nobody ever been around in a situation like that. What about we covered other cases or divorce custody issues. What about jealousy? Is jealousy a reason that someone might lie and say someone did something when they didn't actually do it? Like example, let's say you've got let's say you've got friends or sisters or whatnot, if one of those who weren't with the significant other potentially lie about that person having done something in order to cause trouble in that relationship. Anybody known anything like that to happen? Especially in terms of husband, wife, or boyfriend, girlfriend, or. So what I'm asking about is, I'm just trying to brainstorm, right? And I'm thinking about reasons that someone might lie and say something happened that it didn't happen. So what if you got two sisters, right? Or two sorority friends, and one of them, likes the same person that their friend or sister is dating. Is it, have you ever heard of someone lying because of jealousy to try and cause issues in a relationship? Anybody think that's impossible? No? Okay. So last kind of question, right? It's the golden rule question. Is there anything, and look, it's often in little misdemeanors, it's not that misdemeanors aren't also serious, but obviously, if you've got somebody who's been shot, or if you've got a child that if something has happened to, it's, you get a lot more people who might have sensitivities about those issues, but is there any reason that you can articulate that you think you might not be a good fit for this jury?
I'm available. I don't know if that was.
Smith Shipley?
I used to work there. I work for Mr. Alex Stelly at Silver East Cooking Stelly. That's a defense civil.
Okay, civil defense.
Mm-hmm.
Let me ask this, just in general, I don't anticipate this matter is going to last more than, perhaps an afternoon, maybe two, but, anybody have any type of, medical appointments or something like that, they can't miss either Tuesday or Wednesday afternoons? Nope, everybody good? All right, well, look, thank y'all very much for going back and forth. Thanks for listening, and I look forward to getting the present case to you.
Okay, ladies and gentlemen, gonna ask that you follow the bailiff into the hallway. We may have to call some of you back in for some follow-up questions. So at this time, as the panel exits the jury room, everyone please stand. Everyone please stand as the jury exits the jury room. Okay. Go to be recess.
We heard.
Maybe suited. Somebody's missing. Jury number 10.
Oh, okay.
Already. Yeah.
Jefferson County Court at Law number 2 is back in session. The court is in session. In cause number 24 CCCR 1754, case is styled in the state of Texas versus Jason Wayne Bickford. Let the record reflect that Mr. Bickford is present in court with his attorney. And let the record also reflect that the state is present with their assistant criminal district attorneys. At this time, ladies and gentlemen, we have Miss Linda Segur. She's our court coordinator here. She's going to call some names. When your name is called, please go to the jury box. There are some tags right on the countertop. You can take a tag, have a seat in the jury box, and pin the tag on it. At this time, Ms. Segur, you may be forward.
Larry Newman,
Larry Newman,
Catherine Cheryl,
Catherine Sherrill,
Marilyn Barrett,
Marilyn Parrott,
Chad Wade,
Chad Wages,
Jonathan May,
Jonathan May,
Gary Jones,
Gary Jones,
Adrian Allen.
and Adrian Alex. Okay, you can pin the tag on you. I'll give you some time to do that. Okay, ladies and gentlemen of the jury, earlier I mentioned to you that I had 2 administrative duties. I administer to you the first oath right before we impanel the jury. Now I need to administer to you the second oath. At this time, I need each and every one of you to raise your right hand. And then when I finish administering the oath, please say, "I do." Do each of you do solemnly swear that in the case of the state of Texas versus Jason Wayne Bickford, the defendant, you will a true verdict render according to the law and the evidence, so help you God? Please say, "I do." Okay, you may put your hands down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and other court decisions interpreting them and how they may apply to this case. You and I have equal authority in this case, but it is divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of the witnesses and the weight to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses or objections to the introduction of documents or objects. This means that in objecting attorney's opinion, there is a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can't hear the discussion on the point of law. The reason for this, as I told you earlier, you are the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her. And the attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of the case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspaper or watch TV reports about the case, and do not go on social media to find out anything about the case. Do not make up your mind about the case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during the break if a trial or other proceeding is in progress. Now, the badges that you have, you'll be allowed to take those badges home with you. And so when you come to the courtroom every day that you come to the courtroom, make sure that you have those badges attached to your clothing, because those badges identify you as a juror in this case. Now, ladies and gentlemen of the panel, first of all, I'd like to thank you for your time and attention. I know some of you probably wish you would have had an opportunity to participate as a juror in this case. However, as you see, we only have a limited number of people that can be selected to serve as jurors in this case. Now, you might feel disappointed, but do not feel disappointed, because you helped us to move our docket. And what I mean by that is, before you even showed up today, as I mentioned to you earlier, we had a docket this morning. One of the dockets was a jury trial docket. This case, along with other cases, was on the jury trial docket. And because these cases were set today, and because jurors were scheduled to come here today, we were able to move cases. And just to give you a little understanding, in a few months ago, the state made an offer to settle the case with individuals who had cases on the docket, and they have a right to accept or reject the offer. Some people reject the offer because they think that, you know what, I'm gonna reject this offer because I don't think the jury's gonna show up, or I don't think any witness is gonna show up. But on days like today, when jurors show up and when witnesses show up, sometimes individuals have a change of heart because they realize that today is where the rubber meets the road. And so you are able to help us to move cases. And we like to thank you for showing up today because you did help this court to move cases. Now, I know that when you came to court this afternoon, you probably looked over the top of the door and you said that, you know what, this is County Court at Law number 2. This is Judge Holmes Court. I'm in the right place. Well, this is County Court at Law number 2. I'm the presiding judge here, but this is not my court. This is the court for the citizens of Jefferson County. You are the citizens of Jefferson County. I'm only a humble public servant. So anytime that you are in the area of County Court at Law number 2, you can come and have a seat in your courtroom. You can sit in an area that you sit in. We call that the peanut gallery. But it doesn't mean you could bring peanuts in here to eat because this is not the Texas Roadhouse. But you can come and see what goes on in Jefferson County, and I can assure you that you will find it to be very interesting. Now, your jury service has concluded, and before you leave, I usually give everyone a handshake. Again, you know that we still have COVID in our community, and however, I still like to give you what I call an air handshake. So on behalf of County Court at Law number 2, I'd like to thank each and every one of you for coming out today. And our bailiff, she has some letters that she's going to give to you. If you'd like to drop us a line, please feel free to drop us a line. Now, if you would like to watch the trial, you can come and have a seat in the gallery and watch the trial. We're going to start back tomorrow at 1:30. Or if you cannot be here in person, you can watch it on YouTube. Okay? Let's go to County Court at Law number 2, Jefferson County, Texas. Judge Terrence Holmes. You'll be able to watch it on YouTube. We'll start back tomorrow at 1:30. Okay? And so if you need any excuses, I think the the district clerk's office is closed at this time. But if you need something, we can have our court coordinator to give you Mosby. We can have our court coordinator to give you a letter or whatever you need. Okay. So at this time, your services are concluded. Our court bailiff is going to hand you some letters before you leave. Again, thank you for your time and attention, and every one of you have a blessed day. She's gonna do something. Her, I think it's the district clerk, they close at 4:30. Yeah, just have a seat.
Yeah, the district clerk, just.
Okay, yeah, the letters. Come on.
That's fine.
Oh. Okay, ladies and gentlemen, of the jury, the court will be in recess until 1:30 on tomorrow. On tomorrow, please have a seat in front of the courtroom. And then when the bailiff is ready, she'll come out and get you. Okay? So we'll see you tomorrow at 1:30, and everyone have a blessed day. You're welcome. Everyone, please stand as the jury exits the courtroom.
I'm gonna make more for Oh, good. I did the clipboards last week.
I'm just looking at this.
Still on YouTube.
Yeah,
Hey,
We saw about, right?
yeah, I would.
still on YouTube.
I'm sorry.
I'm not gonna even. Judge, I'm gonna leave my computer, but.
Okay, hold on a minute. Okay, the court will be in recess.